Hello, my name's Elizabeth Dwomoh and I'm a barrister at Lamb Chambers and I specialise in commercial landlord and tenant law as well as commercial law and general chancery matters.
Hi, I'm Antonia. I'm also a barrister at Lamb Chambers. I specialise in real property, landlord and tenant, and contentious wills and probate.
This is the second in a series of our webinars on Landlord and Tenant Act 1954. In our previous webinar, we discussed terminations from the perspectives of both the landlord and the tenant.
In this webinar, we will consider renewals again from the perspective of both the landlord and the tenant. First, Liz will discuss renewals by tenants, and then I will discuss from the landlord's perspective.
So the tenant's request for a new lease. A tenant whose lease has not been contracted out of the security of tenure provisions under section 24 to 28 of the Landlord and Tenant Act will have an automatic right to the statutory continuation of their tenancy under section 24, until such time that it is determined as discussed in our previous webinar. A tenant may, however, wish to acquire a new lease on the expiry of their existing contractual term. In my segment, I'll focus on the following four areas: matters a tenant should consider prior to the expiry of their existing lease, how to request a new tenancy, the courts process, and the points to remember. So what matters should a tenant consider prior to the expiry of their existing lease? A commercial tenant should keep under review their business needs and how the same will impact their premises requirement. At least 24 months before the expiry of the existing lease, a tenant should start considering whether they wish to acquire a new lease or terminate the existing lease. They should check whether they have a copy of their existing lease. A landlord has a right to refuse a tenant's request for a new lease if any of the statutory grounds of opposition under section 31 of the Act is made out. A tenant should also be aware of the basis of how the new rent will be calculated. It is usually the open market rental value of the premises at the date of the rent review. The existing lease may link any new rent to RPI. It's a good idea for the tenant to obtain a rental evaluation to know what the current market rent is for similar premises. The tenant should also ensure that they meet the eligibility criteria before requesting a new lease, namely that the tenancy was granted for a term certain exceeding 12 months or for a term certain and thereafter from year to year. So how does a tenant request a new tenancy? Commercial tenant can apply for a new tenancy by serving a notice on their landlord under section 26. I will call this a section 26 notice. Section 26 notice must be in the prescribed form, which can be found under Schedule 2 to the Landlord and Tenant Act 1954, Part 2 Notices, Regulations 2004, that's SI 2004-1005, form is more colloquially known as Form 3. The effect of the service section 26 notice to determine a tenancy immediately before the start date specified in the notice, the commencement of the new tenancy. The start date cannot be more than 12 months from the date of making the request for the new tenancy, nor less than 6 months after making the request for the new tenancy. The start date for the new tenancy cannot be earlier than the expiry date, the contractual term of the existing lease, or the date it could be brought to an end by the tenant's notice to quit. Section 26 notice must be served with a competent landlord and using a valid method of service. For that, you should look to Section 27 of the Landlord and Tenant Act 1927 and Section 664 of the Landlord and Tenant Act 1954. The notice must be set out in the tenant's proposed terms. That's the rent payable, the premises to be comprised in the new tenancy, terms of the new tenancy, and I find it often useful to include the term of the lease required. A landlord has 2 months to respond to a tenant's section 26 notice. The landlord must specify if the request for new tenancy is opposed or unopposed. If it is opposed, the landlord must set out in its counter notice its grounds of opposition. A landlord who fails to do so will lose the right to oppose a tenant's application for a new tenancy. So I'm now going to discuss the court process from the tenant's perspective. A tenant must apply to court for a new tenancy following the service of a Section 26 notice, or when it receives a Section 25 notice opposing the grant of new tenancy, which Antonia will discuss more in her segment. The tenant cannot make an application to the court within 2 months of making the request for new tenancy under Section 26, unless the landlord has given notice under Section 26(6). A tenant must ensure their application is made within the statutory prescribed time limits. This is very important. The prescribed time limits where a tenant serves Section 26 notice is set out in Section 29A1. An application must be made before the end of the statutory period, namely immediately before the commencement date specified in Section 26 notice. The parties can agree in writing to extend the date of making an application to the court, but this must be done before the prescribed time limit expires. CPR Part 56 sets out the application procedure for a new tenancy. Unopposed lease renewals commenced using the procedure under Part 8, and opposed lease renewals commenced using the procedure under CPR Part 7. Consideration should always be given to whether an application for interim rent should be made. Antonia will discuss this more in her segment. So what points should a tenant remember in conclusion? A commercial tenant should consider engaging a surveyor and solicitor to assist in applying for a new lease, especially with regards to drafting the proposal for a new lease and serving the Section 26 notice. If the landlord has already served the Section 25 notice on the commercial tenant, the tenant cannot request a new lease under Section 26. The tenant must apply to court for a new tenancy in such circumstances. The commercial tenant must ensure their tenancy meets the eligibility criteria for requesting a new lease under Section 26. The Section 26 notice must be made using the prescribed form and contain the required information. The tenant is not required to take a new lease of the whole of the premises. They can request a lease for only part of the premises. Whether the tenant requests the lease of the whole of the premises, they must be in occupation of the whole premises for the purposes of their business. Section 26 notice must be served on the competent landlord. Whether the tenant does not know the identity of the competent landlord, it should make a request for such information by serving a notice under Section 40 of the Landlord and Tenant Act 1954. This notice should be served on the immediate landlord or the reversioner. An application to court for a new lease must be made within the prescribed time limits or before the expiry of any agreed extension. This is important. Consideration should also be given to whether an application for interim rent should be made. This is useful if it will be less than the existing rent. Parties should also negotiate so as to narrow the terms of lease that are in dispute. Over to Antonia.
Thank you, Liz. So moving on to looking at things from the landlord's perspective. As Liz said, a tenant who has a tenancy which is governed by Part 2 of the 54 Act has security of tenure. So the existing lease will continue after the contractual term has ended unless either party terminates or instigates renewal. So a landlord could decide to simply stick with the status quo or decide to instigate the renewal process. But if the landlord does want to instigate renewal, it's really important to make sure it's done right. In my section, I'm going to cover 3 areas: the notice, the application to the court, and finally some handy hints and tips for landlords. So dealing first with the notice. A landlord can end a business tenancy where it's reached the end of the contractual term and propose a new one by serving a valid notice under Section 25. That's the Section 25 notice. That can only be done if the tenant hasn't already served a Section 26 notice as discussed by Liz. The requirements for a valid Section 25 notice were discussed in our previous webinar on terminations, but just to recap, it must be served by the competent landlord. It must be addressed to the tenant, and if there is more than one tenant, to all of the tenants. It must be validly served, and from that perspective, it's important to check both Section 23 of the Landlord and Tenant Act 1927 and also the existing lease and the provisions as to what methods of service are permitted. The notice needs to specify a termination date, and that termination date needs to be not more nor less than 12 months before the termination date specified in the notice. The termination date can't be before the expiry of the contractual term of the current lease. The Section 25 notice needs to use the prescribed form and include all of the information required by Section 25. As soon as the Section 25 notice has been served, either landlord or tenant can apply to the court for determination of the terms of a new tenancy. It's important to make sure, therefore, that the correct prescribed form of Section 25 notice is used. There are 2 different prescribed forms, one to use if the landlord is opposing renewal, which we discussed in the previous webinar, and one to use if the landlord isn't opposing renewal. We're talking about terminations today, so it's important for the landlords to use the form for not opposing renewal. The landlord's proposed terms for the new tenancy must be either attached to or inserted in the schedule to the Section 25 notice, and they must include the following. Firstly, a description of the property to be comprised in the new tenancy. Secondly, the proposed rent. And thirdly, the other terms of the proposed new lease. In my experience, it's also helpful to include the proposed length of the new lease term. There's no requirement to serve a draft lease at the same time as the Section 25 notice, but it's often done as a way of setting out the proposed terms of the new lease and can be the easiest way of doing that. To move on then to the application to the court, if the parties can't agree terms, then either landlord or tenant can apply to the court for an order for the grant of a new tenancy. As Liz discussed, the application needs to be made before the end of the statutory period, which, if the landlord has served notice, is the date on the termination date set out in the Section 25 notice, unless that date is extended by agreement in writing. And as Liz said, any extension must be agreed before the end of the termination date. The claim is made by way of a Part 8 claim using the N208, assuming we're talking about an unopposed lease renewal. And the claim itself needs to include the proposed terms of the new tenancy. Similarly, if the claim has been instigated by the tenant, the landlord will be serving an acknowledgement of service, and again, that needs to include the proposed terms of the new tenancy. Now, there's no requirement for the terms proposed in either the claim form or acknowledgement of service to be the same as those that were set out in the Section 25 notice. So the landlord can propose in its statement of case whatever terms it considers appropriate at that point in time. If the landlord brings the claim, that claim can't be withdrawn without the consent of the tenant, because of course it's the tenant that will benefit from the new tenancy. Similarly, if the landlord brings the claim and then the tenant informs the court it doesn't want a new tenancy, the court will dismiss the claim because the tenant can't be forced to have a new tenancy. So to conclude with some useful tips for landlords. A landlord can state in its Section 25 notice, and indeed its claim, whether it's proposing to grant a new lease in respect of all or part of the demised premises under the existing lease. Section 32(2) gives the landlord the right to require the tenant to take a new lease of the entire premises demised by the original lease, even if the tenant no longer occupies part of the premises for the purposes of its business. But importantly, the landlord must make the election to rely on that provision, Section 32(2), at the time of completing its statement of case, the claim form or acknowledgement of service. If the landlord doesn't include that provision, then the tenant will be entitled to a lease of the holding. That's the part of the property that it's currently occupying for the purposes of its business. Another useful tip is to remember that proposals in the Section 25 notice aren't binding on the landlord and can be changed at any time during pre-litigation discussions, and then, as I said, changed when the landlord completes its statement of case. So the landlord can decide what to include in the Section 25 notice and may want to include proposals based on using them as a tactical negotiating tool. Once the landlord has served a valid Section 25 notice, it can't unilaterally withdraw or amend that notice, nor can the landlord serve a second notice when there's already a valid one that's been served. So it's really important to make sure that the landlord gets the notice right the first time. There might not be a fix. And if the landlord isn't sure, take legal advice and get legal assistance with the drafting. As Liz mentioned, either the landlord or tenant can make a claim for interim rent. Interim rent is not straightforward and can be calculated in a number of different ways depending on the circumstances. So again, if you're not sure, make sure you take advice both on the likely amount of any interim rent and whether or not it should be applied for. It needs to be included in either the claim form or acknowledgement of service. Again, if it's not, then the interim rent claim won't be available. And finally, again, to repeat something that Liz said, the most important thing is for parties to try and agree as many terms of the lease renewal as possible without recourse to litigation, ideally agreeing everything. This can save a lot of time, a lot of cost, and if either party doesn't constructively engage in negotiations, then it may well find itself facing a serious cost order as part of any litigation. Thank you for listening. I hope you found this webinar useful. Please do keep a lookout for our upcoming webinars featuring issues regarding commercial landlord and tenant. Thank you.
Thank you.